Good morning, everyone, and welcome to this webinar, which is part of a very long series of webinars that we are introducing from the iProcureNet project. At this occasion, we will be glad to talk about the tricky question of managing the intellectual property rights, which is one of the components of the public procurement and that has been raised as an important issue to talk about. So we will be glad to have with us Professor Alexei, who will be introducing this question of the intellectual property rights. We will also have Marianne Simovart, who is also a professor at the University of Tartu from Estonia, who will be discussing some of the questions that you may have during the presentation. I will start by introducing the iProcureNet project, which I represent as part of the French Ministry of the Interior and Overseas. I am very glad of being also the iProcureNet project coordinator. The European security market is evolving very fast, and new challenges and priorities for law enforcement agencies and security organizations require a more resilient and responsive procurement. With all these recent transformations, innovative solutions emerge also very fast throughout Europe, and sadly, not all of them make it to the market. This is where public procurers have a crucial role to play in putting procurement expertise at the heart of the security innovation. This is the main purpose of the project iProcureNet, which is to create an ecosystem of procurers, prescribers, legal, financial, and any other technical advisors, and as well as all of the other stakeholders that have a role to play during the procurement process in order to collect, share, and analyze security procurement trends and needs, common and standardized practices, and at the end of the day, gathering all this expertise together to propose, if possible, a joint cross-border public procurement. So the ultimate goal is to make procurement a catalyst for security innovation. The idea is to make projects alive and going from an idea to the public procurement of an innovative solution. This is an H2020 project that is started in May 2019 and lasting for 5 years. It gathers together 14 partners from 10 different member states, out of which 9 are procurement agencies for 1.5 billion budgets. We have also started with some other topics that have been dealing with public procurement throughout the process. So what do we do at the iProcureNet project? We are trying to meet the challenges that we can find throughout the process, from the legal challenges, economic, technical, practical, and as well as awareness and information. Different standards and different regulatory standards and regulations from different member states can be challenging when we are trying to work together for a common objective. Some of them have been identified by procurers themselves, but some other are coming from different stakeholders, such as prescribers and even law enforcement officers from the field, which gives the iProcureNet project a very vast variety of expertise in order to provide the best approach to better procure. The iProcureNet project relies on an innovative 3-cycle process who will pretend and try to map the European procurement environment, comparing national investment strategies, identifying innovation needs, and of course analyzing security markets. This will lead us to establish buyers groups, which are different member states who will be willing to conduct a procurement procedure together if we have a common ground in terms of innovation. We would like to share the knowledge. As far as we understand, the European community is also relying on this sharing of information and trying to find common ground in order to have the best procedures and the best practices when acquiring something for our services. And we will translate this methodology and knowledge through an online toolbox who will give a tailored guidelines and the knowledge based on practical, economic, legal, technical, and cultural aspects of joint and innovation security procurement. The idea is to offer a very complete tool who will guide all the procurers and all of those who will be interested in having a common and joint cross-border public procurement, all the necessary methodology and knowledge through this toolbox. During each cycle of the project, we will be able to collect the methods that we have developed throughout the phases. The idea is to start from the commercial off-the-shelf products or services, what we call currently the COTS. Going through the 3 cycles and trying to identify the procurement of innovation. We go through all these 3 different cycles, which are composed by 3 phases, each of them. We will go through the identification of the needs and opportunities. Then we will pass to a feasibility analysis in order to choose the best segments and the most important ones, and trying to decide and to propose the best way to procure all those needs. So at the end of each cycle, we will have a different release of the toolbox. The toolbox will be nourished by all of this production in each cycle, and we will get bigger at the end of each release. So our methodology includes, of course, this kind of training and workshops and all of the conference, and as well as the webinars and all the information that we can share with you. And we try to address all this information and gather with you the best practices when procuring something. We also keep in mind that our main objective is always to respond to an unmet need. And if by doing so, we get to have an innovative solution at the end of the day, that would be the best. And when possible, we could do that together with some other member states. In order to have all this network of people who are involved in these areas, we are constructing this network inside of the iProcureNet platform, who will be represented by institutions and experts who are somehow involved in the public security procurement. Our assets relies on this expertise from different fields. As I was saying in the introduction, we have legal, financial, prescribers, and of course procurers who will be willing to share with us all the best practices. If you are really interested in joining this already big group of different partners that you can see on the screen, please do not hesitate to stay in touch and visit our website at www.iprocurenet.eu. We also have a Twitter and a LinkedIn account if you are curious about our fundings and our work. But this is the idea, to construct this network. And if you are somehow interested again in these matters of innovation or public procurement, please don't hesitate to contact us, and we will be glad to share this experience with you. Thank you very much. I will pass the floor now to Marianne, if I'm not wrong, for a presentation of the next point of the agenda. Thank you very much.
Thank you, Jorge. And hello, welcome everyone. I'm very glad to have you all here. We actually received a great interest in this webinar and already before have gotten some questions. These questions will actually be submitted, addressed in the presentation, but I encourage everyone to write questions in the chat, and we will certainly try to find some time for a question and answer sessions in addition to the presentation. So before I give the floor to Alexei Kelly, my good colleague in the University of Tartu, and before we go deep into the intellectual property issues, which is a very interesting area of law, I would like to say just a few words why we chose this topic today. And of course, as Jorge mentioned, one of the major aims of is to clear or enhance readiness of the EU procurement community to purchase innovation. And when we talk about innovation, and obviously innovation by definition means something that is not yet there, something that is created or is yet to be created. So whenever we think of creation, you know, there must be a creator, several of them. And they all have certain intellectual property rights with regard to their creation. At least that is my understanding of intellectual property means. And that is the reason why I think we should have a discussion and in general about intellectual property rights. So perhaps I am wrong, but I hope very shortly Professor Alexei Kelly will my understanding of law. Without further ado, please, Alexei, the floor.
So it's quite interesting opportunity to discuss this exciting topic, how to combine intellectual property and public procurement. Because my main field is intellectual property. I've been doing intellectual property, I think it was already 2003. I started my work at university, and so basically when it comes to intellectual properties, and I've been in different positions. I even had an opportunity to be head of committee codifying Estonian IP law, which actually which meant that I had to read all norms, international and EU norms, which somehow regulate intellectual property. And of course, work with different strategies. And one way or another, intellectual property also interacts with public procurement, because of course it's not this kind of official division, but I would say that we have certain innovation law, body of law, which could be called innovation law. And I think that in addition to intellectual property, which is part of this innovation law, it's also public procurement, which is part of innovation law, because one way or another, public procurement and intellectual property, they influence innovation. And of course, the main issue is that how you structure law and how you apply the law in this way so that it would be most beneficial to society. In addition to this work with different innovation strategies, open data strategies and intellectual property regulation, I am also a member of Court of Honor of Estonian Bar Association and Clarin ERIC, which is international research infrastructure dealing with intellectual property and personal data protection and similar issues. But okay, I start my presentation with with a slide where I used this, in a way, this artificial intelligence solution which creates certain personas. And then I had discussion with Socrates. I asked about why should you study intellectual property law, or why intellectual property law is important. And the answer was that it depends on your perspective. Why do you need to understand intellectual property law? Why do you need to have knowledge of it? And within current framework, I think that what we are doing and how we need and why we need intellectual property is to place it within framework of public procurement. Yes. Actually, before this presentation, I did some research on the topic, and what I discovered that it's not really there is not too much research in this field, because there is a lot of research in intellectual property and there is a lot of research on public procurement. But when you look at this, how these two disciplines interact, then I don't think there is enough research. I think this field still needs to be explored. I'm not saying that no one is doing research in this field, but what I'm saying that it's not so extensive. Okay, but let's start with this policy documents. When we look at policy documents, then these policy documents concerning public procurement, innovation procurement, they have some guidelines. First guideline is that member states and public buyers are encouraged to take strategic approach to IPR when dealing with public procurement. But of course, when you read this sentence, then actually it doesn't tell you much. Well, and because it's not really self-explanatory. It says that you need to take strategic approach, but it could mean anything actually. That what is a strategic approach? Okay, then another clause is that defining clear IPR clauses in the tender documents is thus important for public procurement. I think it's quite technical issue. It's not so much policy issue. Of course, it makes sense that when you're buying intellectual property or you're licensing, then you should regulate. But I'm not familiar with practices in other countries, but I don't think that in Estonia it's such a great issue. Probably it's defined. I think that the definition of IPR clauses is problem. I think the main issue is that how this clause is defined. This is the problem. But of course it's not excluded because like different entities are engaged in procurement, so it could be realistic that sometimes they are not adequate. So it's not addressed at all, or it could be a problem. But I think that this kind of technical issue, it's not very hard to solve. This kind of, you can explain to us that you need to add this provision and that's it. But I think that what is a bigger challenge that public procurers, they ask what is necessary. You shouldn't ask more and you shouldn't ask less. Another guideline which like provides certain insights about innovation procurement says that public buyers must ensure that the allocation of intellectual property rights in their procurement takes into account applicable IPR legal framework. So basically it says that you need to follow the law. It's also, I think that it's also technical guideline. It basically technical guideline in this sense that it says that when you are like drafting these clauses, they shouldn't be illegal. So basically, and it also doesn't say much how to address intellectual property. It says that you have to have clauses, and when you have these clauses, then these clauses should have certain regulation. But it doesn't say how this regulation should look like. Okay. And now another explanation from this innovation procurement guideline, which says that basically we have two options. In a very simple way, yes. One option is that the procurer buys intellectual property. It buys. So basically, you buy all rights. Right? In the field of intellectual property, it's called like transfer or assignment of rights. Of course, but this assignment of rights, it's not so clear cut. This assignment could relate to specific rights. Because I explained later, intellectual property is like a bunch of rights, many rights. And so basically when we are talking about transfer, the question is that transfer of what rights? When it comes to intellectual property, and this transfer can be also concern certain jurisdiction. I transfer rights concerning Estonia. I don't transfer rights concerning some other, like use for other jurisdiction. And of course, another option, in addition to transfer or assignment or sale, in a very simple way, it's licensing. And this licensing also, it has very many options. Is it exclusive licensing that basically you give all rights away, all these exclusive rights for use, or it's non-exclusive use, whether it's field of use, commercial use, non-commercial use, and so on. Yes, but mainly yes, when we are talking about this like transactions with intellectual property, then our legal toolbox is rather limited. In legal toolbox, basically we have these options: is transfer. We have like license, basically two main options, and of course in between there are many different subcategories. But yes, this is the option. This is the option. But of course, when I look at situations that very often procurers, those who are buying, want to get most of it. They want to buy everything, anything. But of course, I'm not saying that it's necessarily good strategy. But anyway, so this is the background. We have certain guidelines. These guidelines say that first, when you're doing this procurement procedure, you have to pay attention to the intellectual property. And when you're dealing with intellectual property, then you have a couple of options. This is a like starting point of our discussion. Okay. Now, moving forward with intellectual property rights, then the situation with intellectual property rights is a bit complex. Complex in this way that intellectual property rights are not traditional property rights. First, what you should have in mind is that intellectual property rights are defined as human rights. It's Universal Declaration on Human Rights says that everyone has a right to protection of moral and material interests resulting from the scientific, literary, and artistic production of which he is the author. In European Convention of Human Rights, intellectual property is protected as possessions, because when you look at this court practice of case law of European Court of Human Rights, then intellectual property is defined as possessions within this context, and there are cases which say that for instance, intellectual property can be in different stages. For instance, when you're applying for a patent, applying for a trademark, then it's application, and even this application is considered possessions within this framework. And of course, when it's granted, right, it's also possessions, and when a state somehow infringes this right, then like individuals can rely on this convention. Of course, when it comes to EU Charter of Fundamental Rights, then it says expresses verbis that intellectual property shall be protected. So basically, it's human right based on these international instruments. And of course, what makes transactions complicated is this moral part of these rights, because when you see this Universal Declaration of Human Rights, then it says that moral and material interests. When it comes to material interest, then it's easier. But the problem is that of course, it depends on perspective whether it's problem or not, but it has very personal dimension. Intellectual property has very personal dimension to this creation, and there is some kind of there is even like explanation that intellectual property is like spiritual child of this person, and this makes these transactions complicated. And I think that in this kind of construct, when a procurer tries to take all rights, then they are not necessarily valid. Actually, it comes back to this like second slide, which says that you should know national law. I think that especially when it comes like French jurisdictions, then copyright and intellectual property is really strongly protected. And actually the same is in Estonia and many other countries. In common law countries, it could be different, but especially in this kind of continental Europe, then because of this moral approach, there is quite strong protection. Okay, let me see. Here is official definition. When you're talking about intellectual property or any other subject, then it would be good to have certain universal definition. And this universal definition is provided by Convention establishing World Intellectual Property Organization. And basically what it says, it says that intellectual property means rights resulting from intellectual activity. So there is intellectual activity, and based on this intellectual activity, you have certain rights based on intellectual activity. And in essence, intellectual property rights are negative rights. intellectual property rights, they don't give you any right to do anything, like they are not positive rights, but they are negative rights. Basically, in other words, when we are talking about intellectual property, we're talking about that exclusive rights. Intellectual property are defined as exclusive use excluendi, which means that rights to exclude others, And basically, what patent rights mean, or they mean that when you have patent rights, it doesn't mean that you have right to do something, but it means that you have right to stop others from doing. And why I'm talking so much about this kind of like concept, I think it's in the end, not in the end, but soon I go back to procurement, and this procurement is really affected by this nature, because when you are like acquiring these rights, then you have to understand why do you need them for, because in essence they are negative rights. Basically what they say that you can stop others from using this certain information. This is the concept of intellectual property. It's not like positive right, but it's negative right. But this is universal definition of intellectual property, basically rights resulting from intellectual activity. Okay, let me, okay. And we have intellectual property rights can be divided into three main categories. First is copyright. Copyright is legal basis for IT sector, different kind of copyright. Copyright protects software, it protects databases, architectural works. Because when I see that, when I look at the Estonian situation, that when it comes to intellectual property and procurement, then very often this object of procurement is concerns architectural works, buildings, I don't know, some kind of infrastructure object like bridges. It concerns software, of course, also written works. For instance, I see that when like public authority like commissions certain like analysis, then this analysis is like, no, in a way it's like codified as written work. Basically, it's some kind of report, and then procurer actually wants all rights relating to this work. And sometimes this kind of intellectual property clause is so extensive that it doesn't even allow research use. And of course, this gives rise to a question that does really this procurer need this kind of rights that I'm not even allowed to do research? I'm not telling, I'm not discussing here like trade secrets, that maybe like this kind of in the like police is doing some kind of procurement to get some kind of like technology, some kind of which is protected by trade secrets. No, I'm talking about like these ordinary reports which are published online, but still as a procurer they takes all rights which they don't really need. And yes, intellectual property has three main categories. It's like copyright related rights, industrial property, and this copyright covers very many different objects. Actually, when we are talking about copyright, then copyright in fact we have one Copyright Act, but in fact it contains very many Copyright Acts, because it applies to so different objects. Because initially copyright was meant to like protect fine arts. It was like initially copyright was established as a reaction to inventing this like printing technology. Basically, it was result like a reaction to printing technology. But then when time has passed, then so many new objects have been added. It was like, in addition to this like printed works, written works, it's software, but conceptually it's software doesn't really fit into this copyright framework, because it doesn't always protect like it in an adequate way. But still, the situation is that software is protected as copyright, different kind of databases, three-dimensional designs, buildings, construction, parks, could be even design of park could be protected. So I think that when it comes to public procurement, then copyright protected content is very important. What is acquired, and therefore I think that it's important to understand this like functioning of copyright system and what it protects and what it doesn't protect. related rights. To some extent, it's important. I think that most important part for public procureur is this sui generis database. Actually, copyright also protects databases, but copyright protects databases, so to say, like creative databases, when you have creative input. But sui generis database means that this database is created as based on some kind of investment. It's a lot of investment, but it doesn't have to be creative. I don't know, this classical example is some kind of phone book. I don't know, some kind of technical data is mapped, then it's related right, and then this object of procurement is like related rights. Because other classical related right is like performances, phonograms. For instance, when this procures certain audiovisual material, some kind of like short movie clip, then actually this procurement should cover copyright and related rights, because performances cover these related rights. And of course, we have industrial property. Industrial property covers patents, trademarks, industrial design, trade secrets. I think that the trade secret could be object of certain know-how, could be object of procurement. So you need this information, and in this kind of course, in this kind of situation, it makes sense that secrecy is needed. Some kind of secrecy clauses that the person who provides the secret information is obliged to keep the information secret. Sometimes patented technologies are required, maybe even trademarks, industrial designs. So basically, what I have covered is that intellectual property are rights resulting from intellectual activity, and they are they have form of copyright-related rights and industrial property, and all they are relevant for. Public procurement. And one additional aspect here is that intellectual property protection is not so clear cut. When something is protected as copyright protected work, it doesn't mean that it isn't protected as any other instrument. Therefore, I think that when we come back to these first slides, when it says that you have to have adequate understanding of existing laws, and then it means that when you are acquiring certain information, usually the intellectual property protects certain information, then the same information could be covered with different instruments. For instance, you are acquiring some kind of industrial design, you are acquiring design, but at the same time, it's covered with copyright protection, because it's based on EU law. This cumulative protection is possible. Basically, you have to acquire both these two types of rights. You need copyright and you need industrial property rights also to have freedom to use. So there is no clear cut protection. There are overlapping protection, and when you are dealing with public procurement, you need to have it in mind. Okay, I don't know. It's it's like fuzzy, quite fuzzy slide, but anyway. So. Just shortly, I explain it because when you are very often when you do transactions with intellectual property and even public procurement, these rights are invisible. These rights are invisible because when you are when I am buying something, I don't know, like a song in a digital form, then I'm not buying it because I want intellectual property rights, but I want this song. And it's actually this kind of thing, it could cause confusion because you have to, in your contract, in your procurement, like these documents, you have to combine these two aspects. First, you are buying products, and then you have to address intellectual property aspects, because it's not really intellectual property that you're buying, because it's not your goal, because of course you have to deal with intellectual property, but when for instance, I'm buying a computer, I'm not buying it because it's covered with so many intellectual property instruments. So when I'm buying a drone, it's not I'm buying it because it has IP in it. I'm buying it because I need this drone for some other things. And when I'm buying technology, then I need this technology. This form of protection is, of course, intellectual property, related rights, industrial property, but the object why I'm doing it lies somewhere else. It's certain functionality, it's invisible. This intellectual property are invisible, but when I'm not dealing with them, it's a problem. And of course, content is that I have to agree on use of rights. This is important. This is important thing. Okay. Another thing, and when you're not working in this field of intellectual property, then sometimes it's hard to follow and hard to understand. It's very important to distinguish intellectual property from tangible property, because when I'm buying, when for instance I'm using public procurement to buy computers, then I'm not buying intellectual property. Basically, it's very important. When I'm buying drones, I'm not buying intellectual property, because the transaction is not about intellectual property rights when intellectual property is incorporated into tangible object. When I buy a painting, for instance, I don't know, some kind of public authority wants to buy a painting, then public authority, the procurer, is not buying intellectual property. They are buying painting. And of course, this painting is covered with intellectual property rights, which is copyright. Painting is protected as copyright, but this transaction, it's very important that you understand when you're doing this kind of transactions that whether you're buying product, or as you use this off-the-shelf product, or how you use this terminology, it's like box product, or how to say. Basically, when I buy this box product, I'm buying CD, for instance, music CD, then I'm not buying intellectual property. It doesn't give me any intellectual property rights. I have this CD, and when it comes to tangible property, then this tangible property rights are exhausted. Tangible property rights are exhausted, which means that when I buy software, like in a box, when I buy a painting, then I can resale it. But it's about tangible property. It doesn't give me any rights over intellectual property. But intellectual property is very distinct. So coming back to this distinction, because when we are comparing intellectual property and like tangible property, then they are different in this way that intellectual property has it's territorially limited. It's territorial rights. Patent rights are valid only if I have patent in Estonia, then these patent rights are valid only in Estonia. For instance, in Sweden, someone wants to use this technology, they don't have to have this any public procurement. They can use this kind of technology without any. They don't need any consent, because it's important to understand that intellectual property is territorial right. It's not universal, because when I have jacket, I go to Sweden, my property right is still valid. No one can take away my jacket, say that, oh, it's like Sweden, it's property rights don't apply. They apply universally. But when it comes to intellectual property, it's territorial. Of course, when it comes to copyright is not registered right. Then its copyright protection is automatic, and based on Berne Convention, almost 200 countries agreed that there is national treatment. Basically, Estonia is protecting Finnish copyright protected works, and Finland is protecting Estonian copyright protected works. It's this kind of. But yes, they are territorial, and especially when it comes to registered intellectual property, then it's important to make sure that this intellectual property is valid. Sometimes entities, people make this mistake that they are buying intellectual property which is not valid, because when you have tangible property, then it's quite, you understand it, that you can touch it, you can, I don't know, put it on your table when it's a small object, but with intellectual property, it's more complicated, because basically you are buying exclusive right. You're buying exclusive right, but first you have to make sure that the other person has this exclusive right. Of course, in essence, intellectual property rights are protecting information, and information is public good. It doesn't have any use limit, but intellectual property rights create artificial use limits. Basically, they give exclusive rights. And of course, what makes it complicated is that we have moral rights, which make all these transactions complicated. But intellectual property is also limited. Like patents, 20 years, copyright 70 years, post-mortem after the death of the author. Of course, there are exceptions, like trademark protection is without limitation, and trade secret. Okay. And I think that more or less all intellectual property instruments can be described as I have done in this picture. Basically, all intellectual property instruments, they have to have right holder, the person who has these rights, object of protection, it's whether it's like work, whether it's invention, whether it's some kind of secret information, criteria of protectability. it's whether it's registered right or it's not registered right. And I think that what makes procurement of intellectual property tricky is that it could disappear, because when I am buying, I don't know, TV set or drone, then usually it doesn't disappear. But when it comes to some kind of patented technology, then patent can be invalidated, which means that at one point you don't have this exclusive right on this information anymore. And of course, IP system, it also has like regulation on what kind of rights you have, what is the character of right, what are exceptions. It's also about enforcement. And this box is about this international law, EU law, and national law. Like they should exemplify the case that IP is very heavily regulated internationally and on EU level, which means that it's quite it's not very national discipline. It's quite universal. Coming back to copyright, then copyright usually creates a lot of tension. Here I have like reproduced some quote from Mark Twain. And usually copyright creates a lot of tension. People, I think that good copyright law is that makes everybody unhappy. Yes, coming back to copyright, because I just planned to just pay some attention to copyright protection, because I think that quite many times when you have procurement procedure, then it focuses on copyright. You need copyright protected content and rights. Copyright protection is can be characterized that it's extending constantly. First, it had only like printing material, but now it has software, databases, and so on. And it has additional rights, distribution rights, making available rights. So the catalog of rights is like extending. Okay, so another issue. Which should be like addressed and considered during the procedure is that it's really good when you buy something from single owner. Sometimes there is joint ownership. Which makes situation complicated. Of course, this joint ownership could appear. This joint ownership could appear also later, because someone has contributed to this idea, and then, especially when something becomes commercially successful, then there will be like many people who say that I also contributed, and the problem is that when you are using, you have acquired these IP rights and you are using, then it will be you who will be sued, and this joint ownership could also mean that blocking of the use. I don't know how it's in other countries, but for instance, a situation can be described that when I was just driving around in Estonia, sometimes there are houses when half of roof is replaced. Half of roof was new and half of roof of the house is not new. And so it shows what joint ownership means. Basically, they own the house, and so just only half of the roof is replaced, even though it would be really reasonable to replace the whole roof. But no, half of the house is painted, half is not painted. And European system is that basically all owners have to agree on the use. Basically, when we have created together something with some of you, some kind of piece of intellectual property, and you are owner of 99%, and I'm owner of 1%, and to use this intellectual property, then we have to agree. And if I don't agree, then you cannot use it. And so I think that this whether this clearing intellectual properties is really important, because if there is some kind of ownership claims, then it could stop entire process. And actually, it could this could create problems for you also when you are just using someone else's intellectual property and creating something. It could be joint ownership, and you end up in some kind of lock-in situation. You cannot, you can only buy this kind of. You have to keep buying this intellectual property from this person you bought intellectual property. property. I think it's danger of becoming like stuck in this lock-in situation. Anyway, this what you can remember is that this joint ownership could be a problem. And when you're acquiring intellectual property, you are not necessarily aware of this joint ownership, because someone can come up later and say that I contributed to this knowledge and claim ownership, and then you are in a quite complicated situation. Then you have a lot of legal disputes. But the idea of public procurement is not to have legal disputes, but to do something, to use something, to create some value. This is the idea, not to just create additional jurisprudence. This is not the idea of procurement. Okay. I won't waste too much time on this copyright protected content. What I just like to emphasize that it's autonomous concept of EU law. Basically, it's defined through European Court of Justice has defined it's autonomous concept, and basically what it says that when creation is original in this sense that you have created it, it's your own creation, then it's protected. It's enough when you have created it. Now here it's just reference to different. I understand that you will share these slides with participants, so just when someone has some interest, then they just can look up all this case law. And it's extensive case law on copyright protected content about photographs and so on. And basically what they say is that when it's original contributions, then it's protected. Why I'm telling you this is that when you're acquiring, the biggest challenge is that you have to understand the object of protection, what you are buying. Because it's not, and when you're buying copyright protected content, then you have to know what it is. And here is some reference to some case law, more reference to case law. But basically what it says that it has to have some kind of it's your own creation. Copyright, differently from patent law, is that it doesn't have to be new, that no one has done it, but it has to be original in this sense that it's your creation. When you have created it, even though it exists, it's still copyright protected, and you still need permission for this use. And this quote actually is meant to explain that copyright protection is automatic. There is no registration compared to industrial property. Industrial property is registered right, but intellectual property is not registered right. Let me see. Yes, and the main challenges come from moral rights. As I said before, when copyright, this foundation of copyright law was founded in places, Berne Convention in 1886, then the copyright was about poetry, about paintings, but now copyright protects software, databases, building bridges, technical infrastructure, and so on, these drawings of technical infrastructure. But at the same time, this foundation hasn't been changed, and we still have moral rights. Because one thing is to have moral rights in poetry, because it's not, you don't really have to change a poem. When someone has written a poem, you don't really need the right to change the poem. But when someone has created software and you are acquiring the software, actually, then you need right to change the software. And this is a challenge because because it's the main legal ground for protection of international legal ground for protection of moral rights is Berne Convention, which says that independently of the author's economic rights, still the author can claim authorship, say that acknowledge as author, but it's quite complicated when it's like software, how you do it, or some kind of bridge or building. Object any distortion, mutilation, or other modification. The dangerous part is this other modification, which means that when you have acquired software, because software is quite dynamic object, you need to change it. But when you haven't addressed moral rights, then the person can come after you and say that it's other modification. Basically, you are not allowed to change, and this is a tricky part when you need to address moral rights. It's not only economic rights, but moral rights. More or less, we have four types of moral rights. First is attribution right, but the attribution right usually it's not complicated to follow. Basically, you attribute who has done it, you attribute, but what is the tricky part is right of integrity. Basically, this right of integrity means that the author can stop you from changing the software, changing the database, changing architectural drawings, unless you have addressed this integrity right. But the problem is that since there are moral rights, it's very hard to regulate them contractually. It's a real challenge. There are constructs which need a lot of like legal work. And even this kind of like simple right that has right of disclosure, because this right of disclosure was designed when intellectual property or copyright was about poetry and painting. Of course, it made sense that when I write a poem, it's really up to me to make this poem public to society, to read it out loud or to print it. But when it's all software, you are buying software, they are selling you copyright, and then the author still has a right of disclosure. But when you're using this software, basically you're disclosing. You also have to like regulate this right, or this right of withdrawal actually. Author, even when author has like transferred your economic rights, at certain points they can come back to you and say that no, I don't want you to use it. I don't want you to use this content anymore. Okay. Of course, then you have like more economic rights about reproduction, distribution, but this kind of rights, it's easier to regulate. It's easier to regulate. It's economic rights, and usually they are transferable. But the main challenge is that economic and moral rights have certain overlaps. The same right is, for instance, you have economic right is right of alteration of the work, right to change the work, and at the same time you have a right of integrity, which are like overlapping rights. Okay, so much about copyright protected content. A couple of words about protection of like this kind of technological information. When inventor person has technical information, then they have certain option. One option is that patent this information, and then of course the question is in which jurisdiction and so on. And the other option is that not to patent and to publish. It's called defensive publishing, so that no one else can patent it or keep it as a secret. And I think that this trade secret could be object of public procurement. A couple of words about trade secret protection. It's firstly, it was designed as a measure against unfair competition. And trade secrets are covering technological information and business information. And I think that sometimes these public procurers, they need to buy this kind of know-how, and their secrecy clauses are important. And the problem is that it's not really so clear-cut that trade secrets are part of intellectual property. They are even more like instrument of unfair competition. But still, they are still buying intellectual trade secrets sometimes. Okay, here I have this criteria of trade secret protection. Since our time is pressuring, I won't go really deep into these details, but they say that this information has to be secret. It has commercial value because it's secret, and the person who claims that it's his trade secret has to take certain steps to protect the information. And the only thing which is not allowed is dishonest acquisition of trade secret. It's not like patent right, but it's like what is protected, that dishonest information is not acquired. And if it's not the case, so trade secret is protected. Patents protect also invention. So, and basically you have to have valid registration. But even when you have valid registration, it doesn't mean that this patent cannot be invalidated. Okay, I think that here I skipped this slide because I had more slides. There are more for participants if you are interested. I just want to move back to procurement issues, because first it helped to cover this background, and now I plan to just explain how to put all this previous knowledge into context of this into context of this public procurement. And so this guideline, what it says that in public procurement, you have to define this intellectual property, who has it, and another slide which says that procuring entities are tempted to get all intellectual property. It's quite human. I think that when I'm buying for it, then I should have it. And so basically what this guideline says that it's bad, don't be greedy, don't want to have it. And but more I think about this situation, I think that it's not so it's not necessarily so simple. It's not that less rights you get, better it is. I think it's in a way, I understand what this guideline says. Basically, what the guideline says that you shouldn't get more than you need, you shouldn't. It's also very fuzzy slide. But basically what it the slide says that you shouldn't get more than you need. And of course, another guideline emphasize here that member states should consider leaving IP ownership to contractors where appropriate. It's also like it's kind of like policy guidelines that take as little as possible. But I'm not sure that it's very adequate consideration always. I think it's depends on situation. And I'm going to explain the situation because this slide, I don't know why it's fuzzy. Actually, when it's in slide, it's quite clear picture, but I don't know, probably the program has changed. When we have intellectual property, there are certain routes how to exploit. You can exploit it internally. It's like technological reputation, for instance, like companies want to attract the venture capital to like advertise their product as knowledge-based products and so on. And of course, they have also option external use, licensing and assignment. And basically what these guidelines are saying, that like assignment or when you purchase IP, then it's bad. Don't buy them, but just license them. But of course, it depends on situation. It's not so clear cut because I tried to analyze what is the difference between buying and licensing. And when you buy, then it means that you have to maintain and enforce intellectual property. When this procurer buys, then it's yours. You are owner, you have to go to court and somebody, or when you buy like a patented technology, you buy the patent, then you have to pay this maintenance fees. When somebody infringes, you go to court. Of course, what is the opportunity is that you can use it without restrictions. You can use for whatever purpose you want. But of course, it's really up to you that whether you need all these uses. Because it's I can't tell you like now whether you need it. It's really up to you to decide what kind of. What is good thing is it's stability of ownership. Because the problem is that when you license something, then what happens when this person sells IP? Basically, it depends on jurisdiction, but you could lose the right to continue to use this IP. For instance, I license like some kind of copyright content to use some software, and then I sell copyright. Then basically the situation is that you cannot use this anymore. Of course, what you can do, you can sue me for damages. But let's say that I don't have any money left, and still you cannot use because when you buy, when you are owner of copyright, then it's stability of ownership. When it's really important for you, you should buy it. Because if you don't buy it, something could go wrong. The person who licensed you this software, then maybe it's not maybe even something that is done intentionally, but person goes bankrupt, something happens, and you could lose the right to use it. But of course, at the same time, we have all these open data strategies and innovation strategies. When public entity buys, then you should also support like innovation. It's not that you keep it, you don't allow anyone to use, but at the same time, other people, other companies could use it. And of course, it's more expensive compared to license, because understand one consideration is that when you're doing public procurement, then it should be like economically beneficial. When you're buying IP, then it's more expensive than licensing. And it could also be, you could also have limited access to best solution, because the thing is that sometimes the person who has technology doesn't have all rights to sell you all this solution. Basically, maybe some aspect of this technology is licensed. And so basically, you could get the best solution when you are licensing yourself, because otherwise this person cannot participate in this procedure, because the person who wants to sell you this technology, they don't have all rights. They have only like limited rights. They could give you limited rights, but since you want to buy everything, then there is a problem. Then this person cannot participate. Another, when you're licensing, no obligation to maintain or enforce IP, but at the same time, a challenge that what is happening when the other party is not doing the enforcement, just ignoring, then it's a challenge for you. Of course, you have restricted use, but maybe it's enough for you. Ownership is uncertain. It could be the case that when something happens to this entity who licensed you this technology, this content, when something goes wrong, then you might lose the right. and you cannot use it anymore. Of course, it's most likely less expensive, and public entity has limited duty to support innovation, because when it's limited use, and it's really up to this right holder to use the technology. Another challenges. I understand that just for a couple of more minutes, I think it's important things I cover, and then we have time for discussion too. You have to consider that there are also issues with background, intellectual property, foreground and sideground, which means that maybe some IP is brought in, but then the question is that some IP is created within the project. And the question is that what happens to this IP, how to regulate, and who can use it? Because it's not so easy that you only buy IP, but you could create yourself also IP, which is based on the bought IP or license. Who owns the foreground IP? Then, of course, another issue is this DSM directive, which tries to protect authors and says that even after conclusion of contract, they can ask for more money. We don't have time to go into this slide, but basically, I understand that idea of public procurement is that this the contract is written in stone. It's not that I come back to you and say that I need more money, but this directive says basically that I can do it. It's not applicable to software, but to some other content it is. And basically, it will be interesting situation how it affects public procurement. So basically, what to say about this, just a couple of more words, and then Marianne will have opportunity to moderate this discussion. What public procurers should do, should avoid the manager dog in the manager policy. When imagine like dog is in the manager, doesn't need this it's himself, herself, but doesn't allow anyone else to use. So basically this kind of like situation. What I didn't address is the state aid issues. Because when you just get IP and start giving it out for others without any payment, it could be state aid issues, and of course compatibility with open data policy. Okay, I think that to conclude, I think that there is no such thing that one size fits all. We cannot say that yes, that more rights you get better it is, or less rights you get it better it is. Basically, you have to design this public procurement exactly to your needs, and you have to pay attention that sometimes to get better solution, you need to buy less, because some entities who have better solutions don't have rights to transfer. You have to address these moral rights because it's very hard to regulate them, and avoid lock-in situation, because when you cannot get away from this, like the person who gives you intellectual property, you have to keep buying. Okay, here it's like final slide. If you are like interested, it's sometimes you can watch. It's quite interesting, like based on this fairy tale of these three piglets who built house. And so, and basically this video exemplifies situations that you need to build house which fits your needs. And the same with public procurement. You have to acquire IP rights which best fit your needs. It's not that more you get, better it is, or less you get. It's really more about your needs. But okay, I have covered more or less everything. Thank you. So Marianne, you can ask now questions.
Yes, thank you very much, Alexei. That was really educating, and I know I will definitely go back to these slides during our next legal research part. Just a technical question. I know I had a little bit of problem with my sound. Is that better now? Can you hear me?
You at least. I can hear and I can repeat the question. So it's
wonderful. So I see we have a question here from Christina. Please address the technological lock-in situation. In case the contracting authority does not procure the intellectual property rights, and then later wants to buy more or buy extra modules.
Usually, of course, when you for instance, you buy certain software, and it's not adequately regulated how you can change it. Basically, you acquire the solution, and it's not really agreed how you can develop it further, and then you cannot do it. You haven't agreed. You have bought certain solution, and then you don't have right to change it. And basically, not to infringe copyright, you have to buy this like amendment or improvement from the same entity, because otherwise, of course, I understand that you have like policy consideration that no, it's not okay that you're just buying from one entity, but at the same time you cannot buy from anyone else, because if you continue working with this product, this kind of solution, then it would infringe copyright. And of course, to avoid this, you have to regulate it in your procurement contract. So we have to have these clauses which allow to change. If you don't have this kind of change clauses, then you have to keep buying. When it comes to this DSM directive conflict with procurement, it says basically that the idea is to protect offer, and it says that the offer is entitled to fair remuneration, and there's transparency obligation, and basically when it doesn't apply to copyright, to software, which is good, but to some other things it applies. And basically, when I assign my rights to you, I license, and then I think that you make more money than this proportion of money what is made using this solution, and my proportion in this is very small. So basically, I can come back to you and say that you have to pay me more, because this directive allows it. But I understand that the idea of procurement contract is that it's not that I first agree on price with you and then change my mind and say I want more money. Usually public procurement law doesn't really like this kind of situation. But here law says that I can do it. And that it's not waivable, right? I cannot waive this, right? We can agree in this procurement contract that yes, I waive, but it's imperative norm. I cannot mandatory norm. I still can come back to you and ask for more money. If you make more money, when this becomes like because when we had some kind of understanding that you make so much money from, but then it becomes like you make even more, and I want my share to be bigger. Then copyright now this directive is implemented in I think in majority EU laws, which says that I can come back to you and ask for more. Of course, it's another question how much these public entities engage in making money. More it's like internal use. I think that presentation, I sent it to organize this presentation, and yes, they can share the presentation. Probably you have your own like network. I don't know with who is.
On the contract modification part, because as you said, there really seems to be at least a little bit of conflict between two directives. One directive gives the mandatory right to change, basically, right to change a contract. And the public procurement law, as you rightly said, restricts it. It's not prohibited. There are cases where you can modify contracts, but it is rather, it's a rather strict framework. So I think I tend to agree with Alexei that at the current situation where we are not sure of this how to solve this real conflict between the two directives, it would be the best recommendation for contracting authorities to really address this issue in the contract, because that is one of the grounds where the public procurement law also allows, well, in certain extent, to change the contract, but it has been clearly established firsthand.
Yes, but I'm not sure how practical issues it becomes, because usually public authorities are not like engaged in some kind of business activities. They are not like, no, of course it could be different, but most likely when there's some kind of procurement, it's for like internal use, or it's or I don't know, situations could be different, but usually this issue with this DSM directive becomes like relevant when someone is making money with copyright protected content. But I don't know how much.
Yeah, in answer to Christina, she asks if we should refer to DSM clause and limit it. I wouldn't perhaps.
You cannot limit it. You cannot limit it. It's imperative.
Yeah. We have another interesting question. What is from Elizondo Cordero? What is the most effective way to ask for the IP rights to the economic operators? Do you have some tips on how to address them in tender phase? So when the contracting authority
economic operators.
Yeah, I don't think the economic operators. That's a really interesting question, because the economic.
I don't understand the question. What economic operators means?
The tenderers.
What is the most effective? Yeah. Okay. What is ask for? Yeah, but it's this question actually it comes down. Why do you need it? It's actually to these last two slides when I'm like analyze difference between licensing and purchase of IP. The question is that first you have to define why do you need, because both ways. Actually, you have two options: whether you buy these rights or whether you license these rights. You don't have more options, and there's a combination of this. And the question is that, of course, what they are doing sometimes in Estonia, they're trying to get all rights, but sometimes they don't need all these rights, because I think that all these obligations to support innovations come from the situation when you have all these rights. Then you have to do something with your rights, because it's not idea that you have all these rights and you do nothing, you just stop innovation. This is a main critique with the situation. But of course, when you don't get these rights, then something could go wrong with this ownership. Someone sells these rights. And okay, I have another question. Estonia copyright sells the product and earns.
If I can add to your response, then in the case from the aspect of industry, from the aspect of tenderers, it's actually there are two situations. One situation is when the contracting authority has addressed the intellectual property rights in the contract documents, then of course you can't do anything but to follow these terms. Well, you can maybe challenge them, saying that they are unproportional or inhibit competition. So that's an option too. But unless you want to do that, you just have to follow the terms. On the other hand, when the contracting authority hasn't addressed these questions in tender documents, that might be something where you should maybe consider submitting this question to the contracting authority and point out that there is vital information lacking.
See this question from Christina from Christina. This CA means contracting authority, I think. Yes. Contract, because since I'm working with copyright, for me it's Copyright Act. Because if people are like, usually they understand things. For me, CI is Copyright Act, but anyways, it's contracting authority. But here I think that you have confused what I discussed before, that it's very important to distinguish intellectual property from tangible property. When, for instance, you buy something which contains intellectual property. When you buy something which contains intellectual property, then rights are exhausted. Because it's very important to understand. When for instance, I buy a drone, then drone is covered with multiple IP rights, but after the first sale, rights are exhausted. I can do with drone whatever I want, especially within the European Union. Of course, this exhaustion doesn't apply outside European Union. It becomes more complicated. But when you buy this like drones, TV sets, iPhones, then I can do whatever. They are part of. I can sell them as a product. It's not really IP issue. IP issue is that when I'm buying intellectual property as such. When I'm buying with software, it's more complicated to distinguish product and IP, because it's about user, about right to use. But when it's embodied in some kind of form, then it's about like tangible property. Can the tenderer come back later and ask extra? When actually the DSM directive leaves out certain types of works like software, but for some other types, basically there is like transparency obligation. First is the offer, the offer, what can do, can just first approach you and say that how much money you make from this, like transparency obligation. And when this like sees that you make a lot of money, then you could have this kind of issue. Of course, when you buy it, this public procurement is meant to buy it, to use it internally, not to make money, then I don't see that this problem could become relevant. But when it's used for some kind of commercial activities, but this IA solutions are software. So actually, to avoid this kind of problems, this software was left out. For these reasons, because it makes things not so complicated. But still, there is some content which is subject to this kind of fair remuneration principle and transparency obligation. But software is left out, and artificial intelligence is basically software and all this model trained on personal data and so on. But it's already personal data issue. Okay. Any other questions? This is kind of topic. Actually, it's like endless topic. It's just more you look into this topic, more complicated it becomes. Less you know, more confident you can be. So then it's not an issue. But more you look into this, more complicated it becomes.
Yes. I think we are a little bit over the time by now, and I am sure that we will be addressing these issues more in the future. Definitely in the course of legal research that I will be doing in the project, and perhaps even in these new webinars. So thank you very much, Alexei, and the organizers, and of course, especially thank you very much for the audience. These were very relevant and essential questions that I got, and I hope to work with them further in this respect.
Great new land. I think it's not so heavily explored and becomes more and more relevant. So it's interesting topic to continue. But okay, thank you. Yes, it was interesting actually. When I started my presentations, and I just got deeper and deeper and deeper. I got then more complicated it became, and so it's. But okay, anyway. So thank you, and so okay.
Good day.
See you next time. And okay, bye.